Hello, and welcome to my presentation. My name is Emily Henderson, and I'm excited to discuss my appellant brief with you today. What is an appellant brief? An appellant brief is a document filed with the appeals court detailing alleged errors in the application of law. An appellant brief will also request remedies that addresses the lower court's decision. As the case is now on appeal, the context of the case shifts, and the brief's discussion of facts shifts from the initial evidence to the lower court's interpretation and application of the law. There are a few steps that have to happen before an appellant brief is utilized. First, the judgment in a case has to be entered by a lower court. Next, an appellant has to give notice of an appeal. Following the notice of appeal, the record collections has to be completed with the appeals court. The record collections brings all of the lower court records to the appellate court for review. After the records are received, the appellant typically has around 40 days to file an appellant brief. When creating an appellant brief for the Federal Appeals Court, look to the Federal Rules of Appellate Procedure, particularly Rule 28. In Rule 28A, the outline for an appellant brief is set forth. An appellant brief is organized into 3 parts. The first part might be categorized as an introduction. This part includes a disclosure statement, if required, the table of contents, table of authorities, and a jurisdictional statement. Once the parties, contents, and jurisdiction are explained, the appellate brief moves on to the second part, the argument. This part encompasses discussions of the issues, facts of the case, and then the argument. The argument is prefaced by a summary and followed by a conclusion. Finally, the third part contains any certificates of compliance that may be required by civil procedure. The Federal Rules of Appellate Procedure may not entirely apply to your federal appeals case, as those rules may be modified by the local court rules. Always be sure to check with the local court for their rules. As we will see in just a minute, the case I am highlighting with my appellant brief was filed with the 10th Circuit Court of Appeals. The 10th Circuit requires a few additional items in an appellant brief. As mentioned, my appellant brief is based on a current case filed with the 10th Circuit Court of Appeals. The case, Gaddy v. the Corporation of the President, is a case that applies the church autonomy doctrine to a racketeer-influenced and corrupt organizations claim, or a RICO claim. The case was interesting to me as the appellant sought to bring forth a class action lawsuit against the Church of Jesus Christ of Latter-day Saints for allegedly participating in fraudulent practices, racketeering, and the collecting of tithing. In my appellant brief, you will see a slight variation from the requirements in the Federal Rules of Appellate Procedure. Those variations are modifications to incorporate the 10th Circuit rules. I will discuss these variations along with a few of the general requirements for an appellate brief on the next few slides. To highlight one of the differences, look at this appellant brief's cover page. In the 10th Circuit, it is required to note, on the cover, if an oral argument is requested. It is also important to note that if you are submitting hard copy files, the cover page for an appellant brief must be blue. Following a cover page, the federal appellant brief may have a disclosure statement, which the appellants for my case did not need. After the disclosure statement, a brief will include 2 tables for reference, a table of contents and a table of authorities. Both the tables are excluded from the word count, as well as the potential disclosure statement. When organizing the table of authorities, the cases are listed first, in alphabetical order, followed by the statutes, and then any other authorities. The table of authorities is to reference the pages of the brief where the authority is cited. In the 10th Circuit Court, passum notation is considered a disfavored practice. In the 10th Circuit, a glossary may follow the table of authorities. A glossary is required if the brief contains acronyms or abbreviations not used in common vernacular. A glossary is not included in the word count and thus allows room for other terms pertinent to a case to be identified. This is evidenced in the glossary example from the Gaddy versus Corporation of the President case. After the optional glossary, the 10th Circuit requires a statement of related cases. This is also not included in the word count and is often on its own page. If there are no related cases, as in this instance, the brief echoes the wording found in the rules. Sometimes even that is simplified down to one word, none. The Federal Court of Appeals requires a jurisdictional statement explaining the legal basis of why your case is in their jurisdiction. Apparently, it is not uncommon to file a brief with a faulty jurisdictional statement. These common errors were called out by Justice Diane Wood from the 7th Circuit Court of Appeals. She stated, "There is no reason why, month after month, year after year, the court should encounter jurisdictional statements with such obvious flaws. One is left to wonder what flaws are seen, as the Federal Rules of Appellate Procedure outline the required elements for a jurisdictional statement." As seen here, the rule outlines the 4 parts required in a jurisdictional statement. First, you must state the basis for the district court's jurisdiction. Second, you must state the basis for the appeals court jurisdiction. Third, you must establish the timeliness of the appeal. And fourth, you must assert that the appeal is from a final order. In my appellant brief, you can see the jurisdictional statement and its required elements here. As you can see, the third requirement of establishing timeliness required a lengthier explanation. In my case, Gaddy versus the Corporation of the President, the appellant first filed a motion to vacate judgment in the district court. When that was denied, the appellants then gave their notice of appeal. This notice would normally fall outside the timeliness window. However, the Federal Rule of Appellate Procedure extends the time for a timely appeal following the denial of a motion to vacate judgment. Once the jurisdiction is established, an appellant explains their case as outlined by the Federal Rules of Appellate Procedure. The argument should also be written in IRAC fashion. All in all, an appellant is allowed up to 13,000 words in their principal brief, and the brief should not exceed 30 pages. After the argument is set forth, and following the conclusion, the 10th Circuit Court requires a statement regarding oral argument. The statement should include all the reasons why it is essential for the court to consider an oral argument. If the court is intrigued by your reasoning, your party may be allowed to present your oral argument to the court. An appellant brief is completed by the inclusion of a certificate of compliance. This document certifies that the brief complies with all the rules governing word count, font style, size, and spacing. This certificate is signed by the attorney along with the argument section of the brief, and then the brief can be filed with the appeals court.